Welcome back to Business Lunch on CNBC TV18. Now let's move on. And the Supreme Court has finally ended a 15-year debate on whether coconut oil, a small package, should be classified as hair oil or edible oil. Ashimit is joining in with us to give us details on this one. Ashimit, good afternoon.
Well, it's an interesting dispute which stretches back 15 years if you count from the date of the Sestat verdict. Goes back even further to the 90s. The issue at hand essentially is that the coconut oil, which many users apply on their hair, is that hair oil or is that edible oil? This question seems interesting, but it's even more interesting when you look at it from a taxation perspective. The GST that is levied on hair oil is 18%. The GST levied on edible oil is 5%. That's what the genesis of the dispute is all about. This issue traveled from the Sestat all the way to the Supreme Court. We had a split verdict coming in, then we had a 3-judge bench, and today finally clarity being given by the apex court that Supreme Court's view is that it indeed, even coming in small packages, it indeed is edible oil. Now, with that classification, what the apex court has done is that it has made the FMCG makers, the likes of Marico, the likes of Godrej, who produce coconut oil and sell in small packages, they are now all eligible for a levy of 5% GST. So a huge tax relief coming in, especially as far as the industry is concerned, and a setback of sorts as far as the tax department, which has been litigating for a very long time, in finally getting an answer to that question: is coconut oil a hair oil or an edible oil? The Supreme Court having the final word, the last word, saying that in fact it is qualified as edible oil. Back to you.
Okay. Coconut oil dispute finally getting some resolution there, qualified as edible oil. But on that note,